Colleagues, we will call meeting number 16 of the Standing Committee on Public Safety and National Security to order. Today, we will be dealing with Bill C-483, an act to amend the Corrections and Conditional Release Act, the escorted temporary absence, put forward by Member of Parliament from Oxford, Dave McKenzie. Just before I start with that, colleagues, I would just like to, as Chair, thank you for having your witness list in to the clerk in time so that we've been able to proceed with everything all in favor both for today and for Thursday. Very much appreciate the cooperation. I will just make a note that just at the very end of today's meeting, we will just take about a minute or two I have a request for budget approval for witnesses for this particular bill. I'll be asking for your consideration on that for approval. And today's meeting, of course, is televised. And I just bring to your attention that this is great, and I thank all the representatives of all the parties for their cooperation and concurrence in having this meeting televised today. But in the future, of course, it would certainly be good to know that the day or two before so that we could potentially avoid any maybe last-minute expenses that come along with the last-minute decision. So I thank you for your cooperation in allaying that possibility today. Of course, in the second hour, we will hear from the Office of the Federal Ombudsman for Victims of Crime, Sue O'Sullivan, and all from the Parole Board of Canada, Mr. Harvey Seneko. So at this particular point, we will turn to our first witness, Mr. Dave McKenzie. You have 10 minutes, Member of Parliament, for your opening address.
Well, thank you, Mr. Chair, and I am pleased to be here with you today to discuss Private Member's Bill C-483. I firmly believe this bill provides a good balance between the need to reintegrate prisoners into the community and the need to do everything in our power to keep the Canadian public safe from harm. Even if we have not been personally affected by crime, it is not hard to imagine the relief that a victim of violent crime or their family feel when a criminal is removed from the community and is safely behind bars, or the comfort they must take in knowing that this particular prisoner cannot seek out the victim and commit another act of violence. It's also not hard to imagine the stress and concern that same victim feels when they find out the prisoner has been granted an escorted temporary absence from the penitentiary. Even for a temporary absence in which the prisoner is under escort for the entire time, the mere thought of the prisoner being back in the community is extremely difficult. Regardless of the reason, Canadians want assurances that all possible measures are taken to ensure their safety when a prisoner is out in the community. These safeguards are contained within the Corrections and Conditional Release Act, which outlines the necessary controls and criteria that must be met for each type of absence and is deemed necessary for each individual prisoner. Escorted temporary absences can be divided into two main categories: those that are obligatory or necessary, such as for court proceedings or medical treatment, and those that are for rehabilitative purposes, such as for community-based correctional programs. Now, there is no question there are some circumstances when a prisoner must leave a penitentiary for obligatory reasons, such as for court appearances. In these cases, the releasing authority determines and applies the proper security escort up to and including the use of physical restraints when necessary. These decisions are straightforward. Even the highest risk prisoner needs to be taken to a court date if he faces new charges. It is when we get into the discretionary absences, in other words, those that are more for rehabilitation, where victims become more concerned about how decisions are made to allow the prisoner to be absent from a penitentiary. The decision to send a prisoner outside penitentiary walls for correctional programming reasons is made using greater discretion, taking into consideration the prisoner's engagement in the correctional plan and the risks they pose to society. Today, decisions on escorted temporary absences for rehabilitative purposes for those serving life sentences are made by either the penitentiary warden or the Parole Board of Canada based on a scheme outlined in the Criminal Code. That formula is as follows. For prisoners serving life sentences, the Parole Board is the releasing authority from start of sentence up until 3 years prior to full parole eligibility. Once within 3 years to full parole eligibility, the Correctional Service of Canada takes over as releasing authority. And for those prisoners who committed murder before they turned 18, the Parole Board is the releasing authority from start of sentence up until expiration of all but 1/5 of the specified number of years the offender is to serve without eligibility. Once at the 1/5 mark, the Correctional Service of Canada becomes the releasing authority. This switch in releasing authority from the Parole Board to the wardens is what concerns victims of crime and many other Canadians. They want to know why the Parole Board isn't the releasing authority for the entire length of a prisoner's sentence. They want to know why they, as victims and families, are suddenly shut out of the decision-making process for the final years of the offender's sentence. They want to know why a non-elected and unaccountable bureaucrat is replacing someone appointed by the Crown as a decision-maker. It is easy to understand their concerns. Over the past several years, our government has made a number of legislative changes that place more discretion and authority upon members of the Parole Board of Canada and that give victims a larger role in the conditional release system. For example, in 2011, the abolition of the Early Parole Act gave the Parole Board more authority when deciding if a white-collar criminal is eligible for parole, allowing it to consider an individual's risk of committing a new offense before the end of their sentence. And in 2012, the Safe Streets and Communities Act included measures that now enshrine in law the right of victims to attend parole board hearings and make a statement, and expanded the definition of who can be considered a victim. Measures like these have contributed to a greater public understanding of the conditional release decision-making process. and it only stands to reason that victims of crime want every opportunity to use their newly enshrined rights. To this end, they want the parole board to remain the releasing authority for all discretionary absences, regardless of the number of years left in an offender's sentence. We may not be able to fully understand the pain and loss that friends and families of a murder victim may experience, but we can certainly appreciate their desire to want to play as large a role as possible in decisions that may allow prisoners to be conditionally released into the community. This is really the underlying push behind my Bill C-483. Shifting the authority for rehabilitative escorted temporary absences completely to the parole board gives victims the opportunity to be part of all of those types of decisions, thereby further empowering them. This is a pledge that our Conservative government has made to victims of crime and to all Canadians year after year, that we will do everything we can to safeguard families and communities. I believe this legislation will help us in these efforts by addressing victims' concerns and providing assurances that their safety comes first and foremost. Thank you, Mr. Chair, and I am now happy to take any questions you may have.
Well, thank you very much, Mr. McKenzie, and certainly then we will start our round of questioning. And first off, we will have Mrs. James.
Thank you, Mr. Chair, and welcome to our committee, Mr. McKenzie, and I would like to thank you for bringing this bill before us. I think it is important legislation, and I think it's something to your background as well to bring something like this before our committee today. And I really commend you for having it come this far. I know how difficult it is to get a private member's bill to committee. I listened to your opening remarks, and we understand the basis behind this and how the parole board works with regards to these offenders. But I'm just wondering if you could speak a little bit as to why you actually decided to take this bill on. What was it that prompted you to want to change the system to ensure that those that commit some of the most serious crimes, first and second degree murder, are actually having their cases heard by the parole board as opposed to simply turning over to the institution's warden?
Well, thank you for the question. And the big issue here is primarily police officers and prison guards that are murdered in the line of duty, and those sentenced to the maximum sentence of life in prison. In particular, my interest was raised a great deal in this by a victim of a police officer's widow, who the police officer, and you'll hear from the widow in her words, and I think that is important that you hear that. But Kim Hancock's husband was murdered in Toronto in 1997 by two women, and she's a very astute woman. You'll hear in her words exactly what it means. She's been through the process with the National Parole Board and understands that process, appreciates the opportunity that she has to present her feelings to the National Parole Board. But then what happens is, and in this case in particular, National Parole Board said that these people, and one of them in particular, should not be released. And then the system then, in that last 3 years, it goes to the prison warden. The prison warden decides that there should be a release, and I think she found that it wasn't right, it didn't feel right, and I agree with her, and for that reason we have this bill.
Thank you. I appreciate that answer. I just want to, something in your opening remarks, you said this switch is, I'm just reading it, this switch is releasing authority from the parole board to the wardens is what concerns victims of crime and many other Canadians. I think anyone listening to today's committee meeting would agree with that statement. I think it's, you can correct me if I'm wrong, but someone who is being heard by the Parole Board of Canada up until the last 3 years prior to full eligibility could actually, the day before that 3-year period, appear before the Parole Board of Canada, and then the very next day go to the warden and ask for the same thing and be approved, where the parole board had actually said no, or maybe there was conditions applied. Is that something that, can that actually happen? That's the essence of why I brought this bill forward. When National Parole Board is charged with that responsibility, and they go through their process, including having people attend before the National Parole Board.
then the warden releases someone, and this is not meant to be punitive, but they release someone that National Parole Board has turned down, and then the victims get no notification. They don't get the opportunity to appear before the warden to have their opportunity to explain why they don't think someone should be released. And that's the sort of the part that they find it very difficult from a victim's perspective, is that they've then lost any opportunity to have their feelings known.
This is almost a backdoor parole process.
Yeah, they I think you'll hear from most folks that they agree with the process with parole. They agree with national parole. They might not every time agree with national parole decisions, but they've had an opportunity to have input in it. The system now, as it is, it leaves national parole and goes purely to the warden of the prison, and that doesn't feel right to them.
Thank you. And I just, for the record, I want to make clear that it's not in any way that I think that the wardens are not capable of making certain decisions, but I think the fact within this particular case where it's dealing with first and second degree murderers who are actually going through the parole board instead of the institution wardens, the fact that this bill speaks to that and believes that for the last remaining 3 years they should also be going through the parole board, I think most Canadians would agree with that perspective as well. With regards to the victims themselves and the fact that they've had the ability to be participating in the parole board process and to attend hearings or provide statements and so forth, do you feel that to suddenly have the authority to release that particular offender being done by the warden and having an individual not be made aware of that or not have the ability to speak to that, is that further re-victimization of that individual?
Yes, it is, absolutely. Now, and I'd like to make it perfectly clear that there's nothing that the wardens are doing is wrong. It's the system that's wrong as opposed to the wardens. The wardens are making these decisions based on their reasoning, and they're not the wrong people. It's the system is wrong. We've allowed it to, or not only allowed it, but it's in legislation that they can do it. And, I think most Canadians would be shocked to know not only the victims, relatives and so on, but I think most Canadians would be shocked to know that when you get to that final 3 years, it's up to a prison warden, even though national parole may have said no. And
this, just a final statement again, this is only for the most serious of crimes we're talking.
Absolutely.
Okay.
Yes.
Thank you very much.
Okay, fine. Thank you very much. Now, Mr. Garrison, 7 minutes, please.
Thank you very much, Mr. Chair, and thank you very much, Mr. McKenzie, for being with us today. Certainly on our side, we understand the concerns that victims of the very serious crimes have, but we have several times expressed our concern that we've had a lot of private members' bills which amend various parts of the Corrections and Conditional Release Act. And so we become very concerned about unintended consequences of the various things that are happening here. So something that you said in your opening statement, which is a bit technical, I want to go back to. Because from reading the text of the bill as submitted, it's not clear to me that this only applies to rehabilitative temporary escorted absences. Certainly the summary of the bill does not say that, and certainly none of the sections of the bill as presented say that. It makes an exception for medical absences, but this bill as presented makes no reference to things like the court appearances. And so maybe that requires a more complex reading of the Corrections and Conditional Release Act to see that, but I cannot see that in the bill as presented.
Yeah, Mr. Garrison, I don't have that at my fingertips, but I think that is a given that the wardens always have that for temporary release for medical purposes, and I think I indicated in there of for court appearances and so on, the obligatory options.
With respect, and a copy of the bill certainly that I have in front of me, I don't see it anywhere.
Okay.
It only says medical emergency. It does not say mandatory court appearances. So by my reading of the bill and with the limited knowledge I have of Corrections and Conditional Release Act, this may not be forming your bill may not accomplish exactly what you intended, and I think that's an important question we'll perhaps have to get legal advice on if you don't have.
No, I would agree with you that you should get legal advice. You shouldn't take my word on it. But I think if you look at Section 17(1)(b) of the bill, I think it does spell that out.
But certainly, I guess I see the reference to it there, but what I don't see is in your new subsection 1.1, where you have a new section that deals directly with that limited category of those convicted of first or second degree murder. I don't see a reference to it in that session. So the 1B that you refer to says, for all those other than.
But I think, with all due respect, I think you've got to go to where the National Parole Board can release for those purposes.
Okay, well, I'm going to ask for further legal advice
Yes,
another
no,
time,
absolutely.
because on
yes.
the face of it, I don't actually see that. Another question I'd like to ask, I know we have limited time as we go through these, is did you consult anyone on the impact of this on work of the National Parole Board? In other words, how many of these kinds of applications from those who are convicted of first and second degree murder are received by wardens every year, and how many of those would be shifted over to the parole board?
I didn't do that, but I do know that murders of police officers and prison guards is not a large number, and National Parole are responsible for those releases up to that final 3 years. So, you know, it would seem that it will not increase significantly the amount of work that National Parole does anyways. I can't tell you the numbers of convictions. I should know that, numbers of convictions for people murdering police officers and prison guards, but that number is not significantly onerous, I don't think, to National Parole.
But again, with respect to the bill that we have in front of us, there's no mention of limiting it to those who murder police or prison guards. It says all of those convicted of first or second degree murder. But
you've got to go to the bill.
Well, the copy of the bill that I have in front of me, I don't see any reference to that. So,
if you look at 17 sub 1, other than an inmate convicted of first or second degree murder. So,
but that's a much larger category than police and prison guards.
But the purpose is that the warden can continue with that temporary release of people other than those convicted of first or second degree murder.
I understand that, but what you have said in your remarks is that this will be limited to those who are convicted of first or second degree murder of police or prison guards.
That's primarily who it will apply to, yes?
But it applies to everyone convicted of first or second degree murder as of the draft in front of me, which is a much larger category. Again, we'll have to seek some legal advice, but what I see as drafted in the bill doesn't match what you've just presented to us.
I think it will only apply to those sentenced to 25 years, and which will catch the first and second degree murder. But you will have other witnesses here that'll have a better answer to that question.
Okay, because I think that's a significant concern we have of unintended consequences if there's a shifting of a major number of these kinds of requests over to the parole board, which already has concerns with its budget and its staffing. I think we create an unintended consequence.
Okay, Mr. Garrison, certainly you've made a couple of points consideration that the committee should consider. You still have a minute left if you'd like, or we can carry on.
No, we'll carry on.
We carry on. Okay, to our next, Mr. McGuire, please.
Thank you, Mr. Chair. Mackenzie, thank you for your presentation as well. And you mentioned in your comments to reply to a previous question about Ms. Kim Hancock's. I wonder if you could supply. Obviously, you felt it was a large driver of the reason for bringing this bill forward. Her situation. Can you just elaborate on why you felt that was so important?
Well, you will get to hear her on Thursday, I believe. She will be here. But the whole incident, this murder, is pretty bizarre. pretty heinous. You know, it was a thrill killing, if you will, by two women. Murdered this police officer, stabbed him in a cruiser. He was left to die on the street. And so, you can see the emotions of the victim here, or his spouse. She was expecting a child at the time that was born after that. So she's gone through all of those things. And then to deal with it with national parole and has had what she would consider, I think, and I don't want to put words in her testimony, but I think you'll find that she understood that process and then was somewhat surprised, if not shocked, to find that one of these women was turned down by national parole, and not very long after that was then released by the warden. Now, as I said, the warden didn't do anything wrong. The warden has that authority to do it and had her own reasons for making that release. All I would say is that the system is wrong that grants that opportunity for these people to be out. So, I certainly I wasn't involved in policing when Detective Hancock was murdered, but I'm certainly aware of the circumstances. It's been an issue that has been out there for quite a while, and I think in this case, it's the release that just continues to make Ms. Hancock a victim.
Yes, I'd just like to ask as well, the current system with the regarding the escorted temporary absences, does the victim have any right to submit any comments to the Correctional Services Canada process at this time?
No, I think the committee probably has documentation from the Library of Parliament that sets it out very well. Temporary absences made by Correctional Service Canada. No hearings are conducted. ETA decisions are made on an administrative basis by institutional heads and by the commissioner or head of a region. And in the other side of that is the decisions made by the Parole Board of Canada. Parole Board has the discretion to hold a hearing for ETA requests. The access to those hearings is non-existent when it's done within the prison context. With Parole Board of Canada, the victim can apply in writing to attend, which may be granted. There's no right to make a statement when the correctional service or the prison head grants it. When Parole Board of Canada conducts a hearing, a victim may present a statement. And I think the other part is that inside the prison system of the release, everything remains within there. It's like I said, it's not the prison warden's fault, but the system isn't as informative as it might be when it's National Parole Board.
Yeah. Thanks. So, do you think that that a more public process for the public Parole Board of Canada's decision-making process is favorable compared to the secretive process that we're under today with the Correction Services Canada process?
Absolutely. When it's done in the open, even perhaps, the National Parole Board, it used to be very secretive system years and years ago. But I think even now that it is far more open, the public understand what the system is and how it operates. And I think that's what gives the system some credibility.
And are you concerned in any way that the Parole Board of Canada will not be fit to make these decisions if they're deemed to come forward with this?
I think National Parole Board is quite capable of making the appropriate decisions.
Yeah, I just, as well, as part of this bill, the addition of Section 17.1 that we just talked about here as well, 1.1, further establishes the criteria that must be used and considered under the EDA decision-making process. That includes a lot of things like the risk to society, the purpose of the absence, the inmate's behavior, and whether a structured release plan has been drafted. So I'm wondering if you could share with the committee why this further establishment is important to clarify for the Public Utility Board, or or the Parole Board of Canada here, pardon me.
Well, and those are, you'll have to hear it from the National Parole Board, but I believe you'll find that those are the standard issues that National Parole Board use when they consider parole for any individual serving a custodial sentence.
Good.
Like, You're finished, fine. Thank you very much. Now we will go to Mr. Easter.
Thank you, Mr. Chair, and thank you, Mr. McKenzie, for bringing forward your remarks on this particular bill. I do say in beginning, Mr. Chair, that I have somewhat the same concern as expressed by Mr. Garrison with the number of private members' bills that are coming forward by backbench Conservative members that all have an impact on either the Criminal Code or the Corrections Act, and sometimes I think they're in contradiction. The last bill we had, C479, it actually was a bill designed to reduce the number of parole board hearings, and we didn't hear from the parole board in that case. We should have. And this one increases the number of parole board hearings. And I just think from a government member's perspective, it would make more sense to tie all this stuff together, all these conditions that people are looking for private members' bills on, and bring it forward in a comprehensive way. The last two private members' bills we had more amendments than we had clauses, and I submit the last one, 479, I think we actually amended it that we changed the intent of the bill. So that's a concern I have, just so that you're aware. In terms of the specifics of this bill, can you tell us how many cases across Canada this would actually apply to?
Mr. Easter, I already responded to Mr. Garrison. I'm not sure. It will not be a large number, simply by virtue of the fact that there are not that many prisoners in the system that this applies to. I would say to you, though, sir, that with all due respect, on our side, backbenchers can bring private members' bills forward. It may not be true of other parties, I don't know, but in our side, you can bring private members' bill forward, and I'm very pleased to have brought this forward. The other aspect of this is I don't know how it would increase the big number that you may anticipate with national parole. In the case that we're talking about, national parole had a hearing and said that the person shouldn't be released.
The coming to, I guess, what the parliamentary secretary said earlier, you're saying that there's not many cases. When I listened to the parliamentary secretary's line of questioning, I was sitting here thinking that the system must be inundated with people, with victims, victims' families, who are having a problem with wardens granting this temporary release. And that's the contradiction I'm seeing between the two, because to listen to the parliamentary secretary,
point of order,
you'd think it was
point
huge.
of order, Mrs. James. Point of order.
Just for the record, I didn't once say the system is inundated by victims or victims' families. I just want to clarify that. I did not say that there was no contradiction in our testimony.
That was the tone of questioning from the parliamentary secretary.
Tone is one thing, Mr. Easter. If it was a direct referral, that's another. Please carry on.
Yes, Mr. Chair, will do. In this particular case, I'm assuming that the warden did grant the temporary release. Is that correct?
I believe that you will find from witnesses that several releases.
Okay, then several. Do you know of any? Because we're looking at the public safety issue here as well. Do you know of any of the offenders who were released by a warden on a temporary release? Did they commit another offense? Do you know of any?
I'm not aware of that.
Okay. The November 2012 briefing document sent to the previous Public Safety Minister, Vic Taves, said temporary absences play an important role in helping offenders reintegrate into society. It cites, quote, the low rate of failure arising from temporary absence, and goes on to say, quote, a gradual, structured, and supervised release process represents an effective means of contributing to public safety, end of quote. Can you provide the committee with any evidence that information provided by the minister was inaccurate? Because one has to look at the consequences of this. If you're saying this is needed, then where's the case that shows that what the Minister Taves was saying is wrong?
I don't think we're saying for 1 minute that rehabilitative releases are inappropriate. They are appropriate. But in some cases, those decisions need to be made by national parole and not by the prison warden. That's all we're saying here, is that these cases, the national parole should have the decision to say yes or no, whether or not. And national parole, sir, with all due respect, you were Solicitor General at one time, and you know that national parole do make releases based on a variety of factors, and including conditions and so on.
No question.
And I don't think you or I would disagree with that. Where we disagree perhaps here is that rule, not because it's taken up by prison wardens outside of their mandate, it's within their mandate. But what we're saying is, and what I'm saying is, that decision should remain with national parole in those cases.
And what we're talking about here is the last 3 years.
Yes, sir.
Off their sentencing. We also know, according to Vic Taves and other evidence, that temporary release actually assists in terms of public safety. The victims had the victims and victims' families had the opportunity to appear before the parole board in previous cases. All that's accurate. I think I'm correct in that. And so, do we want to place another burden on the parole board when it may not be necessary to do so? And in looking at that, can you tell us what you expect the cost to be?
I suspect very little, because National Parole Board are already hearing these people. And, you know, what's happening is National Parole Board is saying no. And I would agree that there are times when release is appropriate. But we have people in prisons in Canada today that aren't not going to get released because for rehabilitative purposes. And we all know that. Some of these are those same people.
Thank you very much, Mr. McKenzie, Mr. Easter. And now back to Mr. Garrison, please.
Thank you very much, Mr. Chair.
5 minutes.
I'm going to return to the points. I've had a bit of advice, and I've gone through the bill again. So the question I want to ask you is, I still don't see that this bill limits this to those who, convicted of murder of police or prison guards. I don't find that anywhere in the bill, and the brief advice I've had, we can't find that. So I was wondering whether it was your intention to limit the bill to that, and if so, would you support an amendment to your bill to limit the effect of your bill to the murder of police or prison guards?
I don't know that at this point that I would say to you yes, no, or otherwise with respect to amendments that you may bring forward. It's my impression that that this will only apply to those situations where, because it gets into the last 3 years, and it's got to be at that point. Like I'm not arguing with you about that situation, but I do believe that you're going to find that it is those who murder police and prison guards who find themselves in this situation with the length of time for the sentence. I mean, I've got correspondence from people that were victims of rape, and they have the same problem, but the sentence didn't meet this same standard here. I could direct you to correspondence or to newspaper articles from St. Catharines, a woman that was brutally victimized and then was shocked when the perpetrator was turned down by national parole, but under the system. But that's not what I'm talking about here. We're only talking about the first and second degree murder.
Okay, and I'm not trying to badger you on this. I just think that, again, you've said it's first and second degree murder. I believe that's what it says, and that is, I think you'll find, a far larger category.
Yes.
And has this potential to increase workload at the parole board. And as well, the question that you were asked before, what's the rate of failure on these temporary escorted absences? that you would make so much harder to get. And everything that we've seen from the documents, again, presented by the Conservative ministers, is that the success rates on escorted temporary absence are very, very high. They're in the 90% range. And so what is the threat to public safety that we're trying to address here?
I'm not suggesting that that's the whole issue. The big part of the issue is that once it goes to the head of the institution, the victims are then out of the system. They've been in the system right up to that point. And I think for the purposes of people having confidence in the justice system, we put that in there to deal with national parole, and everybody respects, I believe, national parole. We may not always agree with their decision, but at least this decision is made under a system that we can understand. When these people end up with the prison, the head of the institution, there's no involvement. It's that.
Well, with respect, there is when they come up for full parole. They're not permanently excluded from the process. It's only of evaluating the temporary absences in that period. But when they come back, when the person comes back to
you're
apply.
right, and that's, I mean, I think that the issues are legion out there about people who have been granted temporary absences and or whatever, and people are shocked then to find that they're in the community. But it's because the community or the victims have never had an opportunity to have input.
Okay, and the second one we looked at was the question of whether institutional heads would still be able to allow temporary absence to attend court. I reviewed the document again. I do not believe that that is there, and so my question was, would you support an amendment, if I'm correct, that would say that institutional heads can still grant approval for escorted temporary absence for court purposes?
Yes, I believe, in my opening address, I believe I said that.
Okay, well, we'll have some professional people look at the drafting, but I believe that that's perhaps inadvertently not there, because that would create a real problem in the court system. It would simply be impossible for the parole board to hold hearings each time someone was going to be called to court.
No, I understand that. I believe it's there also for medical reasons.
It's only there for medical reasons, but I think we can seek an amendment of that.
Garrison, I think your point is made. I think all of us, we heard our witness offer testimony that was his intentions, but of course, should it not be picked up in the wording of the bill, that's something certainly that if an amendment was ordered or clarification was necessary, the committee could certainly look at that, as could the perpetrator of the bill. You still have another minute and a half, should you wish. Oh no, excuse me, no. You are over. My apologies. We're into the different time frame now. Okay, now Mr. Norlock, please.
Thank you very much, Mr. Chair, and through you to the witness, thank you for appearing. Would you not agree with me, Mr. McKenzie, that one of the reasons people send a member of Parliament to Ottawa is to be a legislator?
Absolutely.
And that a legislator brings forward legislation to Parliament, that is not only his duty, but his right and privilege.
Absolutely.
Do you believe that if a member of Parliament is part of the governing party, should that member of Parliament have fewer parliamentary rights with regard to legislation?
Should not have any less than anyone else, and I would welcome the members opposite the governing party to bring forward private members' bills, which they do.
And would you also agree with me that when a member of the governing party wishes to bring forward legislation that impacts a particular minister, and in this particular case, the Minister of Public Safety, that the minister generally, most of the time, if not all of the time, that governing member brings that legislation, brings the private member's bill to the minister involved, and the minister and his staff and his people, and in many cases, I suspect this case, their lawyers look at it to make sure that it does what the member intends it to do, and that this committee, after that process, then has the opportunity to look at it and make any appropriate amendments that they feel is appropriate to the, provided it doesn't change the actual essence of the bill. Is that correct?
I can tell you that in this case, I discussed this with staff members of the former Public Safety Minister, Minister Tays, who has left, and I discussed it with members of the current minister's staff. Where they take it to, I'm not sure. I can't confirm that, but certainly, you know, it wouldn't be right for me to bring forward a bill that impacts a minister's files without having some consultation, whether it's public safety or finance or health.
And would you agree with me that the public minister, having been a parliamentary secretary for the Minister of Public Safety, that generally any of those different pieces of legislation that come before that minister are in keeping with the general thrust and the direction that the government wants to go in, and that it's complementary to the government's agenda?
Yes, I would agree.
Thank you very much. And would you agree with me that this piece of legislation is intended to assist victims with regard to the appreciation of the system by which people... Let's start at the beginning. We have a person. In this particular case, you have said this legislation is designed to deal with mainly murderers of police officers and prison guards, and that those victims, the family members or people who are victims around that, they serve a life sentence. In other words, the person that you're dealing with will be forever without her husband.
Yes.
Because he was murdered. And that this piece of legislation is intended to keep her or potential other victims in the loop. In other words, the parole board has a process to keep people informed as to what's victims. I guess we need to be specific here. Victims, keep them informed as to what's happening with the person who killed their loved one, and that when it is the decision of the warden, because that warden has currently a legislative ability and is not required, and you can tell me if I'm wrong, I don't think usually does, but is not, for sure not required to keep the victim in the loop, and that's the essence of your bill, to keep the victim in the loop.
Absolutely. You mentioned that in this case, Ms. Hancock's is without her husband, but her children are without a father. And I think that we've sometimes, those of us that are, if I said playing the game, I don't mean that flippantly, but we don't have that same connection, direct connection that victims have. And I think as long as they have that opportunity to be part of whatever occurs, they understand then. It's an opportunity for them to have some input into the system, and it adds credibility to the whole justice system.
And would you agree with me that if a prisoner or inmate has to appear before court and the necessary court papers are received by the prison and the process is followed, that the warden has no choice? He must follow the court order presented to him and release that prisoner for the purposes of attending court?
Absolutely. And this is not intended to be punitive to prisoners in any way, shape, or form. The whole idea behind the legislation is to make it consistent with what occurs in the early part of the sentence through to the end of the sentence, so that National Parole, who are the body that sit in these judgment cases all of the time, have that control over it, as opposed to passing it off to the institution head. And like I've said more than once today, it's not critical of the institution heads, it's the way the system operates.
Thank you.
Fine, thank you very much. Well, we've now went through our first witness rounds of questioning, so we will now excuse Mr. Mackenzie, and we will... Oh, excuse me, I have one more. My apologies, Madame Duray-Lefebvre.
Merci beaucoup, Monsieur le...
Thank you very much, Mr. Chair. I appreciate it. No problem, and I appreciate having a few minutes. Thank you very much, Mr. Mackenzie, for being here today to speak about your bill, C-483. It's been good to hear what you've had to say about this bill that you are presenting. Frankly, I think these are quite interesting discussions. To start, you mentioned that you consulted with the staff of the former public safety minister as well as staff of the new public safety minister before presenting this bill. I'm sure you have access to those people. And so I think that's a very fair way to proceed, to inform the minister who is affected and to allow him to have input. And of course you can do that since you are part of the government and you have access. What I'd like to know is, did you consult with other people? Or who did you consult when you decided to present Bill C-483? Were other people involved? Were there other experts that you consulted or whose opinion you solicited on this bill?
I'm not sure if I totally understand what you're searching. I was a police officer for 30 years. I'm familiar with not everything with respect to the whole justice system, but I am quite familiar with many parts of it. And, in this case, we're not asking to change the whole justice system. We're asking for a little tiny change. When I spoke with the ministers, both of their staff in the past, it has just been to be sure that I'm not offside with where the minister is with respect to these things. So I don't know who. I think you're going to hear from some experts, and I think that's appropriate. This is not a big bill, and I think what you will hear from the experts, even if I spoke with them, you would still want to hear from them. So I think it's appropriate that you do hear from them. I think they understand, or I would expect they understand the system, and they can give you that background.
Non, en fait, je cherchais pas à regarder quelque chose.
Well, I wasn't looking for any particular information. I just wanted to know who you had consulted with. On our side, when we present bills or motions, we often consult with experts beforehand to get their opinion. So I was just wondering who you might have consulted. And more specifically, did you consult with the National Parole Board to find out what they thought about your bill?
Some other experts, and I would call them as victims, and I think they're experts in the system. They're experts and know how it affects them. From the perspective of national parole, you'll hear from them. I rather doubt that this is a large number. But you can hear from them. I've talked with, like I said, some of the people in the minister's office that have some background in law, but to go out in a broad sense, this is not a big bill.
Je suis d'accord avec ce que vous avez dit sur...
I agree with what you said about the victims, and I think this is a touchy subject, and it's important to consider the victims as an integral part of the system and to consult with them about this bill. I think that's very praiseworthy. As Mr. Garrison said, with the current bill, it seems to affect those accused of or convicted of first and second degree murder. Did you consider having the National Parole Board do the work that the warden was doing previously? In my opinion, this will significantly increase the National Parole Board's already heavy workload. And at the same time, have you perhaps considered a plan that would allow the board to carry out the changes that you're proposing in this bill?
I guess if I understood what means, you expect that National Parole Board will have additional work. The situation that I'm telling you about is National Parole Board have had this hearing, and they said no. This individual should not be released from penitentiary. But the system, doesn't matter what National Parole Board said today, the system, the way it operates, it automatically then rolls over at this point in the sentence, it rolls over to the heads of the institutions being granted the opportunity to release. It's as if the institution now becomes sort of the quasi-National Parole Board. But National Parole Board has said no, they're not eligible for release.
Oh.
Sorry.
Fine. We're a little bit over. So thank you very much, Mr. McKenzie. And you can excuse me, Mrs. James.
Right, just according to our the rules and so forth that govern our committee, we actually have a full hour for the first witness, and I think we still have some time left for further questions.
You have some time left, but I would like to have unanimous consent to have that time split between a round of questioning, if that's the case. I'm not going to allow one member from one party or nor the other just to have a round of questioning. So, how much time do we have left? We have 9 minutes, so let's just go 3-3-3 if you wish. Otherwise, we will no.
Sorry, Mr. Chair. I just normally we would continue with the round of questioning, whatever the order may be. I'm not sure whether Ms. Dore Lefebvre had actually finished her time allotted.
She had more than finished her time.
Okay, so I think it actually comes back to this side for the next round, and I'd like to continue with that structure, please.
Fine, but we will, if we're going to go a second round, we will still add parity to it, so you have 3 minutes.
Just on a point of order.
Point of order, Mr.
We
Easter.
are going to stop earlier. I think one of our very important witnesses on this bill is the parole board, along with the Federal Ombudsman for Victims of Crime next. That's 2 individuals. I really do not know what more information we can gather from Mr. McKenzie. I think he explained himself reasonably well. And I think we need to go to the people that are actually going to be impacted by this bill rather than promote her at this time.
Well, fine, Mr. McKenzie, or I mean, Mr. Easter, but if you don't wish to follow through with questioning, that would be fine too. We will simply go to it. Was there another point of order? If not, you have the floor.
I would actually like to continue with this witness for the full extent of the time that we're allotted and continue with the next line of questions.
Carry on. I'll advise you when the time's done. Mr. Payne?
Thank you, Mr. Chair. Thank you for attending, Mr. McKenzie. You know, you talked about Kim Hancock's and obviously the difficulties of losing her husband, and particularly when she was expecting. And so I just can imagine the difficulty that she faces. And I'm assuming that she's gone through a number of parole board hearings. I wonder if you could confirm that, or...
I don't know that whole background. She will be here on Thursday, and I'm sure that she's quite well prepared to give you that information. I can say to you that in my conversations with her, she understands national parole and appreciates the work they do. You know, and her belief is that National Parole Board, as is my belief, that until National Parole, when they say no, somebody shouldn't get out, that the prison warden shouldn't be put in the position of being able to allow them out.
Well, you know, and I think that's the whole point of your bill, Mr. McKenzie, in that certainly in the last 3 years, it's taken away from the parole board, and the warden has that authority. And I'm guessing that the individuals impacted, the victims, aren't even notified that in fact this individual could be out on the streets. And I don't know if is that in your understanding?
That's part of the concern, is that these people may very well be back out on the street without the victims or the families knowing about it.
So they're being re-victimized again in this whole process. So, you know, I find it hard to imagine that that someone could get out once the parole board has already said that they're not eligible. So, you know, I think about all of a sudden going to your mailbox and finding something in the mail to say that this individual who murdered your husband or family member is now out on the parole board. So I'm just sort of at a loss of words. You know, I think about families who lose individuals and what the impact is for them. And so it's very difficult, and I understand because I've lost family members, but not through this kind of a situation. But I understand that, in fact, those family members, it takes years and years to get through this process. It's a grieving process, and the loss of a loved one is extremely, extremely difficult. So, you know, I'm supporting your bill in this to make sure that, in fact, when the parole board says no, that is the statement. Nothing happens beyond the parole board because, as you stated, the parole board does, in fact, do an extremely good job, and certainly on rehabilitation and following the processes. So I just wanted to make those comments. Thank you, Mr. McKenzie.
Thank you.
Thank you. We still have 2 or 3 minutes left yet if there's further questioning. Seeing no further questioning, thank you very much, Mr. McKenzie, and we'll suspend now for 3 minutes while we welcome our new witnesses. Well, colleagues, we'll start our second hour, and in this second hour we have two witnesses before us here. We have from the Office of Federal Ombudsman for Victims of Crime, Sue O'Sullivan, and from Parole Board of Canada, we have Harvey Snekel, and up to 10 minutes each, if you please, and we would certainly welcome your comments now. I'll start with you, Mrs. Sullivan. Ladies first.
Thank you. Good afternoon, Mr. Chair and members of the committee. Thank you for inviting me here today to discuss Bill C-483, an act to amend the Corrections and Conditional Release Act. I would like to begin by providing you with a very brief overview of our office's mandate, as the Office of the Federal Ombudsman for Victims of Crime was created in 2007 to provide a voice for victims at the federal level. We do this by receiving and reviewing complaints from victims, by promoting and facilitating access to federal programs and services for victims of crime, by providing information and referrals, and by promoting the basic principles of justice for victims of crime. Also by raising awareness among criminal justice personnel and policymakers about the needs and concerns of victims, and identifying systemic and emerging issues that negatively impact on victims of crime. Bill C-483 seeks to amend the Corrections and Conditional Release Act to shift the authority of the warden to authorize the escorted temporary absence, or ETA, of an offender convicted of first or second-degree murder within 3 years of full parole eligibility to the Parole Board of Canada. At its core, this bill aims to bring a more transparent and inclusive process to victims of crime. I fully support this shift and the benefits it brings to victims. I think it is also important to acknowledge that Bill C-483 specifically proposes to remove granting authority from one organization and give it to another. In doing so, one might question which of the two authorities is the best position to decide on the offender's progress and ability to reintegrate into the community. My remarks today do not in any way reflect any judgments or suggestions that one of these authorities has greater capacity to make these decisions. This is not my area of expertise, and I will not speculate on that aspect of the suggested amendment. Instead, what does concern me, and what I do see as a clear advantage of the amendments proposed in this bill, is the benefit to victims of ultimately having a more transparent, informative, and inclusive process. It is within these parameters that I will provide my comments. Through our work, we have generally found that at a minimum, victims of crime want to be informed, considered, protected, and supported. Given this, it would not be surprising for you to learn that we have heard from a number of victims who are frustrated by the lack of transparency in the warden's process. They find it difficult to understand why someone who has committed a serious crime such as murder could be granted any type of release without a process that informs or involves the victim. In contrast to parole hearings, victims have little to no role in a warden's board process. To be more specific, parole hearings are a much more informative, inclusive process for victims. Victims have a right to be informed in advance of a pending parole hearing, as well as the option to apply to attend that hearing. For those victims who do not attend a hearing, they are able to bear witness to a reasonably fulsome account of the offender's progress and rehabilitation. Even victims who are unable to attend the hearing still have access to the decision registry, which, while not providing a full information about the offender's process, does outline the reasons why a particular decision to grant or deny parole was taken. Victims are more fully considered in the parole process in that they are given the opportunity to update their impact statement, to respond to and reflect the specific release decision being made. Without this opportunity, wardens' boards may potentially review an outdated and/or less relevant earlier version of their statement. Additionally, within the parole hearing process, victims are able to present, not just submit, an impact statement outlining the harm they have suffered as a result of the crime. While not all victims choose this option, victims we have spoken to describe this opportunity to share the impact directly with offenders, an important part of their healing journey. Finally, in addition, there are funds, supports available to help victims cover some of the expenses associated with attending the hearing. None of these same channels of information, consideration, and support are available to victims in the case of a warden's board. As such, I would support the amendments in Bill C-483, which require a more transparent, open, and inclusive process for victims. That being said, while I am pleased to see these enhancements being made for victims of those serving life sentences, Bill C-483 does not address the need for information and meaningful participation for victims where offenders are serving all other types of federal sentences. In these cases, the warden remains the granting authority for ETAs, including non-medical or court-related, unescorted temporary absences, voluntary transfers, and work releases. In practical terms, this means these important enhancements will only apply to approximately 18% of the offenders currently in the federal system, leaving the victims of the remaining 82% of offenders with a process that does not sufficiently inform or include them. While it is my job to encourage the Government of Canada to ensure its laws and policies better meet the needs and concerns of victims of crime, I am also aware that the practical implications of broadening Bill C-483 to apply to all federal offenders and not just those serving life sentences would undoubtedly be of concern to the Parole Board of Canada, would need to be examined and addressed. To address this issue, I would recommend that in amending the bill, the committee consider making all authorities responsible for release decisions accountable for providing a transparent and inclusive process for victims, one that ensures the same opportunities and supports that currently exist for victims attending parole hearings. These changes are important not only as means of addressing victims' concerns, but in strengthening the system overall. We know that procedural fairness is crucial to increasing and maintaining public confidence in the criminal justice system, which means we need a system whereby all participants feel respected, informed, and heard. In conclusion, I support Bill C-483 and its move to enhance the release granting process in order to better meet the needs of victims of crime. I also recommend that these amendments should apply to all victims of offenders currently in the federal system, ensuring that all victims are equally able to access a system that better informs, considers, protects, and supports them. Thank you very much for your time. I'd be happy to answer any questions you may have.
Thank you very much, Ms. O'Sullivan. Now, Mr. Stanenko, up to 10 minutes, please, from the Parole Board of Canada.
Thank you, Mr. Chairperson. It's a privilege to appear today before this committee to speak to Bill 483 and an act to amend the Corrections and Conditional Release Act. I'll briefly provide an opening statement and an overview of the bill's effects on the Parole Board of Canada's operations. Afterward, I'd be pleased to take questions. As the honourable members of the committee are aware, the Parole Board of Canada is an independent administrative tribunal with exclusive authority under the Corrections and Conditional Release Act, or CCRA, to make day and full parole decisions for federal offenders. The board also makes record suspension decisions and clemency recommendations. However, since this bill does not affect the Criminal Records Act, I will confine my remarks to conditional release and to escorted temporary absences, or ETAs in particular. All of the board's decisions are made in accordance with criteria set in legislation and are based on a thorough and careful assessment of the risk an offender may pose to the public if released under supervision in the community. The paramount consideration in every decision is the protection of society. In this regard, the Parole Board of Canada works closely with the Corrections Service of Canada, or CSC. As you know, this bill would transfer the authority to approve ETAs to the board for certain offenders. In my view, it is important to understand how ETAs fit within the Corrections and Conditional Release regime to understand how this bill might affect the board. The Corrections and Conditional Release regime is designed to be a graduated and supervised movement toward increased liberty for an offender, with public safety as the paramount consideration. Its objective is to protect Canadians by returning offenders to society as lawful citizens. ETAs are short-term releases during which the offender is supervised at all times by the Correctional Service of Canada or a person approved by the warden of the institution. At present, CSC has the legislative authority under Section 17 of the CCRA to authorize ETAs for all offenders. However, for offenders sentenced to life, including those convicted of first and second-degree murder, this authorization is subject to board approval until the offender reaches day parole eligibility under Section 746.1 of the Criminal Code. In all other cases, CSC has the authority to authorize ETAs. In addition, all ETAs for medical reasons or to attend judicial proceedings or coroner's inquest are also authorized by CSC. So, for example, to put that more concretely, for an offender who is serving a life sentence with a parole eligibility of 25 years, the board would be the decision-making authority for most ETAs for the first 22 years of the sentence. After this, CSC becomes the authority for ETAs for this offender. There are, if you will, two categories of ETAs. There are ETAs that might be broadly described as rehabilitative. The first category of ETAs may be approved for community service, family contact, parental responsibilities, and personal development for rehabilitative purposes. They may also be approved for compassionate reasons. There are also ETAs that are more administrative, such as those for court appearances or medical care, as previously mentioned. Under law, offenders may apply for ETAs at any time throughout their sentence. An offender serving a life sentence might start with an ETA, and then if all goes well, that offender could move to unescorted temporary absences and work releases. Next, if the offender's risk is deemed to be manageable in the community, the offender may move on to day parole and possibly to full parole. Offenders serving life sentences, as you know, are either incarcerated or under supervision for the remainder of their lives. The first time the Board reviews a rehabilitative ETA application from an offender serving a life sentence, a hearing is set and 2 Board members review the application. The Board considers the reports and recommendations prepared by CSE, as well as all other documentation on the offender's file, including any victim statements or information. Registered victims would be alerted that a review is scheduled. Observers and victims may attend the hearing, and registered victims may provide and present a statement if they wish to. Board members must take into consideration the criteria of undue risk to society, and the ETA must fit within the framework of the offender's correction plan. It must be structured and include specific objectives to be achieved by the offender. In approving the ETA, the Board must be aware of the nature of the proposed escort. Board members may impose any conditions considered reasonable and necessary to protect society, and each ETA is approved on a case-by-case basis on its merits. Following this first hearing and a successful ETA, subsequent reviews are typically conducted in office by 2 Board members. ETA reviews for compassionate reasons are handled differently. They require 2 Board members and are typically conducted in office. The Board works in this way because compassionate ETAs are often requested for unforeseen reasons, such as attending a funeral for a close relative, so decisions are required quickly. According to the law, in its current form, registered victims will receive notification from the Board that an offender has been authorized for an ETA, and CSC will inform them of the date and destination. This is our current system. Bill C-483 would amend the CCRA to grant the Board almost exclusive decision-making authority for ETAs for offenders serving life sentences for first and second-degree murder. Under this bill, CSE will retain authority only for ETAs for medical emergencies for these offenders. Over the last 5 years, under the current law, the Board conducted an average of 119 ETA reviews per year. Operationally, if Bill C-483 passes, because the Board's authority for ETA decision-making will expand, the number of ETA reviews the Board conducts will significantly increase. It is also important to note that the Parole Board of Canada will continue to consider all information provided by victims in statements about the harm done to them. For those victims who wish to, there will be more occasions to provide their statements to the Board. In addition, registered victims will be notified of all Board ETA decisions, as well as the date of and location of the temporary absence if approved. Currently, ETAs have more than 99% success rate. This is no surprise given the strict risk assessment criteria that the offender is accompanied at all times while outside the penitentiary. ETAs are an important element in the corrections and conditional release regime, which serves public safety. When public safety is protected, we serve victims and all Canadians. I thank the committee for its time and attention, and would be happy to answer any questions you may have.
Fine. Thank you very much. Then we will go to the first round of questioning from the government side.
So, Mr. Norlock.
Mr. Norlock.
Thank you very much, Mr. Chair, and through you to the witnesses, thank you for appearing today. My first question will be to Ms. O'Sullivan. Would you agree with me that, and I know in your former life you were a police officer, would you agree with me in the following concepts? That in order for a member of society to appreciate the law, they should have at least a basic understanding of the law and why it is in place the way it is, in order for them to be able to properly comply with social order. And would you then extrapolate that into victims, in order for victims to understand and appreciate the system, in other words, the court system, and then following the court system when there's a finding of guilt, the system surrounding the offender's life in prison, they're part of it. In other words, the parole process, the temporary absence process. Would you say that both are somewhat synonymous? In other words, for the person, the victim, to appreciate why the system is acting, why the system is in place the way it is, and that they, who are the victim, and in this case we're dealing with people who have committed a serious crime, such as the murder of a police officer or a prison guard, and that they, the victim, are serving a life sentence until they die, actually, a full life sentence, that they need to be included in the process, and that this particular piece of legislation is one more step down that path of including the victim in the process.
I think you've touched on several key points for victims. And first of all, you touch on the criminal justice system, and you've heard me, I've been before this committee, talk about, for a victim, how complex and complicated. And one of their basic needs on information is their need for information to understand their role within that criminal justice system, what their rights are, as well as information about the offender who harmed them. The other two words you hear me use all the time when I speak about victims is choice and options, which is respecting their choice to be involved and to have that. But in order to make those choices and choose those options, they need to be informed as to what is available to them. So I think in my opening comments, which speaks to where your final comments were around this, is how important it is for victims to have information, have an opportunity to input into that process, have an opportunity to ensure that their victim impact statement, they have a chance to update that they are informed at all points along that process about their ability to participate. And so with the agency that's going to have responsibility for this, our key points here, that they ensure that it's transparent, it's inclusive, there's an opportunity for them to participate, and that they're informed.
Thank you very much. I know, I think in previous conversations and anecdotally, that you hear from victims all the time, that sometimes as the Ombudsman you want to do something, but if there's no legislative authority, no legislative ability for something to happen, then all you can do is point them in the right direction and give them some advice as to who they need to go to get that piece of legislation changed or whatever. And I wonder if you could share some of your experiences with victims surrounding not just this piece of legislation, but pieces of legislation like it where there's a lack of their ability to let the system know, the people within the system that make it run, like the parole board, to let them know how they're feeling. And I especially would like, I know you mentioned there could be changes to their circumstance that they feel the authorities need to know.
Yes, and I think what we're talking about here is that at all stages, and along the continuum, if you will, that they have opportunities to be informed, to be considered, to ensure that, and I use the word protected, which in many cases victims want to know that the governing authorities are considering their safety issues, and particularly when it comes to different types of conditional release. And so they need to understand that the people who have these authorities to make that are, and that's one way, is through the victim statement. But I also think that when you look at the role that victims in the criminal justice system, you touched on legislation. Well, an agency can only give information to a victim what the legislation says they can. And so why it's so important that we allow them to have a process that they can input. And in my comments, when I talk about a decision made by the Warden Board, there's no written documentation. At the very least, although you've heard me also say we'd like more, a decision registry allows them at least to have some information around that. And so it's a closed process that they don't. So if you were to ask me, in the recommendations that they need to be informed in advance of a hearing process that allows for their participation, they need to be able to present a statement, they need to be able to be informed of their offender's progress, because that's when you're making these decisions again on release, that's what they want to know, that you're considering their safety. They want to ensure that they're provided, they update their impact statement, as we talk about through process, they're allowed to do that. And also, as I said, access to information as to why these decisions are made. And I will also say that, whatever the decision is on the process in terms of this legislation, they should also be financially supported in being able to participate in that.
Oh, thank you very much. And I think you've hit on some important parts there. One of the, I was dealing with a victim very recently who was the perpetrator of a terrible sexual assault on her child. And she was given a piece of a map of the community in which she lived. With her and her husband broke up during the time that the child had been, and the child was had been victimized by a family relative. And they were shown this map of a grayed out area of their community and told that the perpetrator was given the map and told to keep out of the gray marked area by the parole officer who would, and this person says, now I've been targeted. Is this the kind of situation that you have experienced in the past with victims? And do you have some suggestions for this committee as to how we can improve on the process of parole and temporary absence?
Yeah, and I did, and I have made those recommendations that I just went down, so I won't reiterate those. But I think what you're speaking about here is the need for victims in the process to have a sense that they have the information they need to make choices and options, that they are included in that process, fully informed along the way. And also that they can exercise those choices because, as you know, every victim is unique. Some may choose to participate in the process and some may not, and they need to have that choice. The other thing, and you alluded to, and I want to just kind of build on, is that victims may, as well along their journeys, and for many victims it's a lifelong journey, may change those choices and options. And so they need to have the information in order to make these choices along the way. And so keeping them informed, make sure the processes are transparent, that they can participate, are key pieces to this. Thank you.
Helpful to the releasing agency because we live in a very mobile society today. So the information that the parole board may need, if the victim doesn't take part in the process where the legislation permits them to take part, they may have moved, and the parole board or the releasing agency may not be aware of their new address, which might be impacted on the temporary release.
That's certainly one of the challenges that has been identified by governing agencies, that if the victim doesn't keep their file updated, that they may not know. So that's certainly a challenge that's been identified. And that really speaks to the role that we have to ensure that all victims and Canadians understand what's required in part of that process. And so you also asked me how else can we get the victim's message out, and issues of release into proximity around victims is certainly one we hear in our office quite frequently. And so this is an opportunity for us to really ensure that victims are included. That's a challenge, but I think every opportunity that I get as ombudsman, and I've had the opportunity to actually speak at an occasion where I think all of your parole board members were there, and also to participate on a regular basis. So there's many ways that we can use the voice of this office to inform agencies and to continue to have. I have regular meetings with Correctional Service Canada and with the Parole Board of Canada as well.
Thank you.
Thank you very much, Mr. Norlock. And now Mr. Garrison, 7 minutes, please.
Thank you very much, Mr. Chair, and thank you to both of the witnesses for your testimony. And I'm always appreciative of having Ms. O'Sullivan here to remind us that the voice of victims needs to be heard and they need meaningful opportunities to participate. You've made recommendations which go quite beyond this bill, and so I'm not really going to deal with those today. I'm going to ask you a very limited question, and that is, you've made the point that when temporary absence are granted by wardens, there is no notification, whereas when this is done by the parole board, there is notification of the date and the location. So is that something we should, as a committee, be thinking about in the larger sense of requiring, when a warden's board grants a temporary absence, some notification to victims?
Absolutely.
I think that's something that everybody around the table would be willing to consider.
Absolutely. That they be notified that this is coming up, and that, absolutely.
Okay, thank you very much. Mr. Chinaiko, I think I really appreciate your presentation for doing a couple of things. One is you clarified the difference between parole and temporary absences, and I think we sometimes run those together. And I understand why victims do. They don't always understand the difference between those two. But I think it's important at this committee that we keep in mind that those are two very different things. You talked about the rate of success for temporary absence, I'm assuming granted by the parole boards, is 99%, or is that for all temporary absences in the system?
Those are the ones that are the success rate of those. Now, I can give you the statistics in relation to.
But are those for just the parole board ones, or are those include?
It's just for the parole board account.
Okay. Is there any reason to think that the success rate would be significantly less for those temporary absences?
Well, because only 67% of those are actually put forward for the release. So of the 67%, I'm sorry, 63%, is the approval rate for the first time they've had a hearing. So 37% don't, but of those 63%, there's a 99% success rate that they won't reoffend or they don't commit a breach of their condition while they're out on an escorted temporary absence.
So thank you. That's an important part, I think, for all of us to understand. We've had figures from the minister about the success rate overall, and we'd have to take into account, first of all, how many were granted the release, and then the success rate is built on that. I think that's very useful. When the offender becomes eligible for day parole at that point in their sentence, is there any notice given to victims at that point on that temporary absence will be handled by wardens' boards?
Well, wardens have no ability to.
No, I'm asking with the parole board. You deal with these cases up to this date, and I guess I'm also kind of making a suggestion here that when in the existing system, if we don't pass this bill, wouldn't it be useful for the parole board to notify victims that from this point on, ETAs will be dealt with differently?
Right. We have at present time we conduct approximately 120-ish ETA hearings for each year. If it's a hearing, which would be always the pre-release of an offender out of an institution, 2 board members, it's a hearing at the institution normally, and the victims would be invited to attend if they so wished.
But what I'm saying, the question I'm really asking you is, at a certain point, you no longer deal with those requests. Those requests would then go to a warden, right, for ETA.
Once he's, I'm not quite sure if I understand your question. After, of course, after ETAs and they're eligible for day parole, the day parole we would manage. We're advised of the timeline. The offenders eligible for day parole, we set up the date in relation to when his hearing will be. It's a pre-release hearing. It will be in person, and we ensure that the victims are made aware so that they can attend. They can provide a verbal statement. They don't have to. They can provide a video statement or tape.
Again, we're making a distinction. So it's only this very limited escorted temporary absences where victims then would not get a notice when it's done by the warden's board.
That's correct. It's that last 3 years, as Mr. McKenzie, MP McKenzie, mentioned, that it's that last 3 years that is, I think, the greater meaning of his bill.
And so I had a look at the estimates before I came in today, and what I see is that, in fact, you don't have additional resources coming to you at the parole board in the future, even though we have an increased federal prison population. And so in your statement you say that Bill C-83 would add significantly to the work of the parole board. And I guess I'm asking you the obvious question, how's the parole board going to manage that when you don't have in the budgetary allocations any increased funds?
Well, Mr. Chairman, it'd be premature to answer any dollar questions in relation to a private member's bill. However, as it would be approximately 900 additional ETA reviews per year, and that would provide us with provide victims with an additional, roughly 25% of those are hearings, 75% are in-office reviews. That would provide victims with an additional approximately 200 hearings that they could attend and provide a statement regarding this individual.
So this
regarding and again, these are offenders serving life or indeterminate sentences of life from first-degree, second-degree murder.
So it's clear, and I'm not asking you to speculate exactly, but it's clear that it would take significant resources to accommodate this bill.
I can't. It would be premature to respond to how much. We haven't done any. We haven't done any quantification in relation to dollars. This is a private member's bill, not a government bill.
But at 900 additional per year and 200 what victims could attend, obviously resources are required to do that.
And funds are available through the Minister of Justice's program for victims attending hearings.
Okay.
Okay. The chair just looked for some clarification first. So is the chair's understanding that we have like well over 900 plus offenders that are in there for lifers, basically? Sorry.
Point of information as well. I heard Mr. Senenko. I thought you said 900 over 3 years. Randall asked 900 over a year. Which is it?
Per year.
Per year.
Per year, okay.
Okay, fine, thank you very much. We will now go to our next, Mr. Richards, please, 7 minutes.
Thank you, Mr. Chair. Appreciate you both being here today with your perspectives on this piece of legislation. And certainly, you know, I just will add my voice to commit to Mr. McKenzie for doing something to try to improve safety and to try to better accommodate victims in their part of the process. And I think maybe I'd like to start on that vein, but with you, Mr. Senenko, in terms of the parole board, I mean, I think anyone who sits on this committee, we've heard enough testimony from victims to understand how difficult it has to be to go through that very painful process of a parole hearing or any type of a hearing that they're dealing with, where they're having to relive their, you know, maybe a murder of a family member or whatever it might be, a very tragic circumstance that I'm sure must be terrible to have to relive. But to go through that process and then to, you know, have the offender be denied parole, and then only to hear that, you know, a short time later in these kinds of instances that we're talking about today, through a really secretive process, I guess you could say, that murder has then been granted. You know, access to be able to leave the institution must be incredibly painful and difficult for a victim and their family. Could you make any comment, and I'd open it up to you as well, Ms. O'Sullivan, if you have any comment on this. Could you comment, though, Mr. Senenko, on that, and whether you've had any kinds of experiences with similar kinds of situations through your time on the parole board, or, you know, I know you have obviously previous experience as both an officer and legislator in this area as well. So maybe you could just comment on any previous experiences you had with a similar kind of situation and how you would feel about those and how you feel the board would see that.
Well, thank you very much, Mr. Richards and Mr. Chair. The Parole Board of Canada has done additional work these last years in relation to ensuring there is a balance between offenders' rights and victims' rights. And we've worked closely in looking at what other agencies are doing, both nationally and internationally, throughout Europe, throughout the United States, Australia, New Zealand. We work very closely with our partners regarding parole, regarding the work they're doing with victims. We want to, again, be leaders internationally as well in relation to ensuring the protection of Canadians and society, but as well ensuring that victims are provided with the services that they require and the services they need, ensuring, again, that there is a balance under law in relation to an offender's rights in an institution and as well the victim's rights to attend a hearing and or provide information. I'll just, one of the interesting, in doing the research behind this and in preparing for this presentation, at present there are 1,782 offenders who are serving an indeterminate or life sentence, and there are 4,062 victims registered with the board for those lifers. Our total number of registered victims at the board is 7,585. So it shows you that two-thirds of the victims registered with the Parole Board of Canada are for 1,782 offenders when we have 15,000 offenders in institutions across the country and another 8,000 offenders on conditional release in the community.
You can obviously see that there's some importance to these victims in terms of this because of the facts that of what's happened in these kinds of cases to their family member, and so you can see that that's clear in what you're saying with your stats there. And I just wanted to also just be clear, when the board makes the decisions about the escorted temporary absences, you're provided with all the same materials in terms of the correctional plan, etc., that the CSC officials would have when they're making decisions on the ETAs that they're making decisions about, correct?
I can't answer how CSC makes their administrative decision. I can tell you that the Parole Board of Canada will review the file from start to finish, and that file would include the background history of the offender, any societal issues that he may have grown up to through his life, It would look at his criminogenic behavior, criminal activity throughout his life. It would include the judge's comments from sentencing from each time, or just the only occurrence that the offender was sentenced. Our board members would review the police reports in relation to the offence, and looking at the whole picture of the individual, how he got into the institution and the crime, and the nature and gravity of the offence he created. Then they look at psychological assessments, psychiatric assessments while in the institution, his institutional behavior while he's in there, programming, the conduct in relation to the success or unsuccessful programming that he's taking in the institution, and then looking at his community release plan, which is legislated in the CCRA, that there has to be a correctional release plan that he has to work on, that has to be provided for, that he has to work on, in fact, and that this is to ensure the protection of society in a gradual, monitored, supervised release back into the community. Okay. So that's how we assess risk.
Sure. Okay,
and,
I appreciate that. I don't have
how.
much time left, so I just wanted to really quickly get the one last question in. You indicated in your opening statement, and I'm just going to quote back to you a couple of sentences from it. For those victims who wish to, there will be more occasions to provide their statements to the board, so you're talking about with this change. In addition, registered victims will be notified of all board ETA decisions, as well as the date of and location of the temporary absence. So obviously, given the fact that your look as a board at this would be certainly more open and accessible to victims than obviously that of CSC when they're doing that, could you maybe just comment on that? Because I think that what that does is it tells me that that's the more open and accessible process for victims, and that would probably make this a good move in terms of ensuring victims have a better access to the hearings. So if we're looking at this, that would be an aspect that should be considered as well. Both of you could comment if you'd like.
Well, I think we have a process. One, that they're notified in advance. If you're not notified in advance, which you aren't in a warden's board, then how are you going to update your statement? So the kind of process that's going to ensure that they're notified in advance, that they are given the opportunity to provide these and update these statements, that they're going to get information. The frustration we hear from people of a decisions made in a warden board is they can't access any information as to why that decision was made. I don't understand it. How come they made this decision, that kind of thing. And so when you have a process that allows for a decision registry or written information coming out of there as to why that decision was made, so that they can be informed, that they can take the steps that they need to take and feel that they're being respected in this process.
Did you want to comment on it, Mr. Sneko?
Well, as I mentioned earlier, of the 900
process would be
just briefly, Mr. Sneko, please.
Of the 900 edition, as I mentioned, approximately 200 would 25% would be hearings. The other 75% would be officers' reviews, because of course some of these would be an ETA for the first time, but they would be applying for a second or third or fourth ETA. However, it would provide victims with approximately 200 additional hearings that they could. And as I mentioned, in relation to these offenders, there's usually more than one victim, family member, person affected. There's usually a number of them.
Fine. Thank you very much. Thank you, Mr. Richards. Now, Mr. Easter, 7 minutes, please.
Thank you, Mr. Chair. And welcome, Mrs. Sullivan, Mr. Sneko. Two really good presentations. Just turning to you first, Sue. You believe, obviously, from your remarks, that the bill is isolated to cases related to the murder of policemen and correctional officers. There's some dispute about that around the committee, how broad the bill is or how narrow it is. Is that interpretation? Is that your interpretation?
Is that this bill is for all offenders who are in for life or indeterminate sentences. However, I'm not a lawyer, so I defer to the people that.
Okay, and you're suggesting that the bill should be extended beyond that.
Well, when we're talking about applying process here that applies to all victims. And so, I mean, when we're talking about those basics, and I've said them, the needs of victims, it is my job to ensure that we take all these opportunities, and I think we have an opportunity here. We have an opportunity to broaden this bill so that all victims who are registered, have offenders in the system, and want to participate, have the opportunity to have a transparent process, have an opportunity to input, have an opportunity to be informed and protected. And so, yes, I would. That is my recommendation that we expend.
Okay, thank you. My question to you, Mr. Sininko, is under the. Let me put it this way: how many such ETAs or paroles are granted by wardens now? How many have been granted to offenders serving time for murders of police officer and correctional officials? Do you know?
I don't have Correction Service Canada statistics here. I just have our own.
Because
so I can tell you, last year we conducted 117.
Okay.
119.
119. Because we really do need to know how broad or how narrow this particular bill is. My problem is that the bill seems to be based mainly on one case, and that's Detective Constable Billy Hancock's murder by two individuals. So, and maybe you can't answer this question either, but in terms, and as I understand it, one of those individuals has asked for parole. Can you tell us how many parole hearings that offender was granted over time? This seems to be based on just one case.
Yeah.
Do we know how many parole hearings that individual was granted? Was the individual ever granted parole? Do we know how long before the warden granted the individual parole that the previous parole board hearing was held? Those are important questions, and we need answers to.
I think that'd be to disclose that information. I don't believe we can have the ability to disclose that. I think it'd be improper to talk about a single certain case. However, I can say that we worked with CSC in relation to getting our expected numbers of 900 additional. So you could infer that that means that they conducted 900, but I can't be certain on that. However, we got our numbers. We worked with CSC jointly. We're saying we're going to have an additional 900 cases to do because they won't be doing any other than for medical emergencies. They'll be continuing to do.
But that 900 seems to me to be in the broad aspect, is it not the narrow aspect of policemen and correctional officers?
That's everything. That's every lifer and
so we don't
offender convicted of first
so we
degree
really
murder.
Don't have the number that really applies to this bill. I guess, and let me come back another way on this then. In terms of, like, I'm sitting here wondering if this is a situation where and we're looking at a problem in the correctional system that really relates to a warden doing what he shouldn't have done, he or she shouldn't have done. Maybe that warden should have been tuned up by the head of corrections. Maybe this decision shouldn't have been made. And we're looking at changing the whole Correctional and Conditional Release Act as a result. I don't know that. We don't have that information. But let me ask you this. Is the warden required to discuss the granting of a parole with the parole board in that last 3 years? Do they get the file from you? Do they have the file? Do they discuss it with the people who were involved in the previous parole hearing?
No, the legislation, the present legislation allows for the warden to make that administrative decision based on areas that he has to, as well. He has to ensure that the offender won't be an undue risk to society. He has to follow what is in the legislation now.
But I mean,
but there's no consultation between.
Well, I mean, that seems to be ridiculous. It shouldn't be that way, because if you're the parole board and you've held hearings and you base your decisions on certain criteria, and you've said no or you've said yes, in either case, shouldn't the warden be obligated to look at previous decisions made relative to this offender and the issues surrounding that offender?
I can't, Mr. Easter, Mr. Chair, I can't respond on behalf of CSC, other than I can tell you what's in the law today. and that's what we follow as the CCRA.
Mr. Easter.
No further questions. I mean, if I say I'm baffled, which I am, Mr. Chair, someone over there will use it against me sooner or later, but I'm baffled.
Well, we could also say frustrated. Okay, next, second round, Madame Doré-Lefebvre.
Merci beaucoup, Monsieur le Président. Puis,
Thank you very much, Mr. Chair. And I'd also like to thank Ms. O'Sullivan and Mr. Sanaiko for being here with us today. Your testimony was extremely well fleshed out and detailed, and I really appreciate that. That said, I do have a few small questions, and they have to do with things that you said during your testimony, particularly Mr. Sanaiko. I have a question that has to do with your conclusion. You said that the success rate for ETAs was around 99%. As far as you know, the changes being proposed by this bill, will they, in your opinion, increase public safety?
And as I mentioned, the success rate of those 99% is based on the 63% of those that applied. So will that remain the same? I would suggest that it would, based on the risk assessment we do of offenders in the institution.
d'accord. Puis aussi,
Okay. Yeah. My colleague, Mr. Garrison, mentioned this a bit earlier. You said in your speech that you're looking at a number that is much higher, that requests for ETAs would be much higher. And you estimated that it would be around 900 more requests per year, if I've understood correctly. If it's 900, Bill C-483, if it is passed, do you currently have the staff necessary to meet that demand?
Our approximate numbers, because again, this is not a government bill, this is a private member's bill, but the approximate numbers that we have would be approximately 900 additional reviews. Approximately 75% would be in-office, 25% hearings at an institution. We haven't done any of the numbers in relation to additional costs, so it would be premature for me to say, do we have the appropriate staff? Do we have this, that? Because again, there's this bill is still in the motion of going through this committee, and so we don't have any firm numbers on that.
Okay.
I can't tell you if obviously as the bill moves forward and the bill was passed, obviously we'd be looking at the work that has to be done regarding it, which again at that point in time would include looking at the amount of work that would be considered, the additional work that would be required, and as well, taking into account all those things.
excellent. Puis,
Great, thank you. At the beginning of the meeting, when Mr. Mackenzie was telling us about his bill, we talked a bit about what powers CSC would have in awarding ETAs. And the only clause would be that CSC would continue to to control ETAs, but only in the case of medical emergencies. So do you understand the same thing as me? In other words, that when an offender has to go to court, he will have to go through the parole board to make that request? Is that what I should understand from this?
We would do all those. Now, and let's remember, these are offenders with indeterminate life sentences, convicted of first degree, second degree murder. The CSE would continue to do escorted and unescorted in relation to robberies, in relation to other offenses. But just for murderers and indeterminate sentences. We would do all of those except for the emergency medical release.
OK. Puis, Madame O'Sullivan.
Okay. And Ms. O'Sullivan, we agree with the essence of the bill, but I would like to know when an offender has to go to court, now he will have to go through the National Parole Board. Do you have any comments about that?
The Parole Board of Canada and the CSC as to what kind of an administrative, how that will proceed. But my understanding is that the warden, for everything other than murder and indeterminate, that right now the parole board has all of that and does that. So I would defer to them to speak to what challenges they may face on that. I mean, that's really an administrative process that there's been a legal need for them to appear before or go back to a court process. And so the functioning of that, I would defer to those agencies. But I would like to reiterate that, here we have an opportunity for a closed, whatever that process, whatever the decision is to make, we have an opportunity that whoever holds that process for that 3-year period, that they make it a transparent process, that they make it available in a written format, that they can have this, that victims can input into this. And so I would want you, when you ask, is this about, I think this is about an opportunity here to be more inclusive of victims into getting their voice being heard and being respected and being able to input. And so being notified ahead of time if this is actually taking place, because we hear from victims, they may be on an escorted temporary absence pass, but if you're not aware they're coming into your community, you come across them, whether they're escorted or not. I mean, we're talking about, I think, some basic rights for victims to be able to be informed, be able to update and participate, be able to, if they can't participate or choose not to, that they can get this information in a written format. And that's about accountability. That's about whoever's making the decision being accountable for that decision process. We tried to find out how many the data around how many warden boards, and that was unavailable. Like, how many boards do you actually hold? And so when you look at, again, accountability and transparency, I think whoever has that would have to have that.
Fine. Thank you very much. And now, Mr. James, please. 5 minutes.
Thank you, Mr. Chair, and welcome to both of our guests. Now, I just want to, for the record, this bill is about giving victims more ability to be part of the process. In these particular cases, victims have the access to participate right up until that last 3-year period. And I think you said it best, Ms. O'Sullivan, when you said the clear advantage of amendments proposed in this bill is the benefit to victims of ultimately having a more transparent, informative, and inclusive process. I think that's important to note. But I do have a question for Mr. Sinenko from the Parole Board of Canada. Right now, the Parole Board of Canada has exclusive authority to deal with TAs for those serving the most serious of crimes. For all others, lesser crimes, lesser sentences, it's dealt with within the institutional head or by the warden. That decision is made. Why is that?
It's the law.
Let me ask
the CCRA is 1992, so it's really 22 years old. It was probably took 3 to 4 years to be written up and drafted up before it went through Parliament.
Thank you.
So it's an old piece of legislation.
Let me rephrase that question. What is it that you do differently? What does the Parole Board of Canada do differently when reviewing TAs that the institution head or the warden would not be doing?
Well, they are required. Their review is based on what's in the legislation as well. However, our risk assessment, I'm proud to say that we have a very strict risk assessment, as I mentioned earlier, going through all of those areas that when we look at ensuring the protection of the public is utmost in our, or foremost in our minds for all of our board members. We have to go through the criteria as we do if we were going to be reviewing them for day parole. We review them the same way that we would be for an ETA.
Thank you. And you've said that 60% of those that apply, 63% get approved and 37 are not approved.
Denied.
Now, that's based on your in-depth risk assessment. Do you think that those same results would have been achieved had that responsibility been with the institution head or the warden? And maybe that's an unfair question because that would be, I suppose, speculation. But obviously there's a reason why we go through that risk assessment on the most serious of crimes, criminals who commit those crimes.
Exactly, and I can't answer on behalf of CSE. However, I can say the pre-release, any pre-release of an offender is one of the most important releases that we're going to look at, because you have to take everything into account. His whole lifestyle, all the issues in relation to societal issues that he may have grown up through, addiction issues, and then going through. So it's a very studious process to go through in assessing risk of an offender. But this is about protecting Canadians, and we don't take this lightly. So we're going to ensure that we're going to assess the risk, and that the offender, as stated in the correctional release, the release plan, that he won't. The risk is gradual, it's supervised, and he's following a plan that is there for him and in place, and he's supervised. So,
thank you. So, you gave the example of 25 years. The first 22 years, these individuals are under your watch, more or less, and then bam, you've got 3 years left, and all of a sudden everything changes. What magically happens that determines that you no longer have the releasing authority on those individuals, and all of a sudden it goes to someone else that follows a different set of guidelines?
The legislation.
Okay.
I mean, that truly.
Okay, because I think at the end of the day, this is about all of a sudden the victims being shut out of the process. And I guess my time is probably up at this point in time.
You have another minute.
Oh,
yes, they are.
Thank you very much. Just back to Ms. O'Sullivan, to talk about victims being shut out of the process. We've heard the story of Ms. Hancock's and her particular situation, but I think that this particular bill does speak to the need to involve victims in the process from start to finish. Not have them fully participating, the ability to fully participate right up until, again, that 25-year example that you gave, fully participate up to 22 years of being able to be involved in the process, to know that they're part of the solution, part of the answer. Something terrible has happened to them, and they have that right. So here we have the last 3 years of that particular sentence, and I think it's very important that we don't shut the door on victims or the victim's family. I think it's important that we open up the door and allow them to continue with that process. I know you're going to agree with that, but do you have any final comments? Thank you.
Okay,
thank you.
Fine. Thank you very much. Mr. Rousseau, a couple of minutes, please.
Merci beaucoup. Monsieur
Thank you very much. Mr. Seneko, when you do a review, a parole review, what are the steps and what are the resources that are necessary to conduct that review? I mean, just for one hearing, what are the resources and the staff and the time required to perform one review?
Review is approximately 2 hours. Each board member is allotted approximately 2 hours to go through the offender's file. Now, depending on the seriousness of the file, which we're talking, in this case, we're talking about indeterminate life sentences, first degree, second degree murder. So these, in some of the cases, these are extensive files. These are quite large, so it can take longer to review them. So, however, 2 to 3 hours per review would be the approximate time you would allot, depending on the case. It's a case by case.
est-ce que les membres
And do members of the parole board have to conduct research? Do they have to collect information on the situation?
Provided to the board by the Correction Service Canada, who of course are looking after them. So we have their whole file, which includes the court documents, the judge's comments, the police reports, all the psychological reports, psychiatry reports. All of those reports are all included in the file, and our board members look at it, including the victim statements as well.
Yeah,
those are in the file as well. Okay. And so all that is reviewed by the board member in preparing for this is in preparing for the hearing, and then at the hearing, then of course they're asked questions.
So
by
the whole process take about 2 or 3 hours?
In reviewing the file, so there's two. In an office review, it would be 2 hours, and then writing up a decision. Attending a hearing, you would review, study the file, and then prepare yourself for the interview the next day. Go to the institution, have the hearing, which could take up to 2 hours, and interview the offender and make a decision. So,
Thank you very much.
Mr.
Thank you,
Snyder.
sir.
Thank you, Mr. Rousseau. And certainly thank our witnesses for coming in here today. We certainly do appreciate your time and your expertise and your commitment to justice and public safety. Thank you very much. Our witnesses can be excused. Colleagues, before we break, I would like a motion from this committee just to approve the expenses for the witnesses for 43. Could I have a motion? Mr. McGuire, yes?
Yeah, just a
Mr.
question, Mr. Chair. Is this just done in the calculations that it's from Toronto? There is other places in this country besides Toronto. There's 5 witnesses listed here from Toronto.
Mr. Easter, I can ask our clerk to explain, if you wish, the breakdown of how and why, or if you wish to. Do you want that now?
Yep.
When planning this with the logistics officer, I advised that the witnesses would all be coming from Ontario, not all from Toronto. I know that some are driving from other regions, but for the sake of costing it out, it seemed to me that approximately $1,000 per witness from whom we expected expenses seemed reasonable. So for the sake of calculation, I allowed her to use Toronto as the base, and it was only for that reason, sir.
Okay, thank you.
Okay, fine, thank you. Motion put forward, Mr. McGuire. All in favor? Second? Ms. Grant, all in favor? Passed. Thank you. Adjourned till the next one.